Hello, welcome to another episode of Knowledge is Power by Dr. Mrs. Challa Mahalakshmi, an eminent advocate of repute at Visakhapatnam City of Destiny. Today she will be giving us details about the Muslim marriages acts and over to Dr. Mrs. Challa Mahalakshmi.
Greetings everyone. My topic for this presentation is laws relating to dissolution of Muslim marriages. At the outset, I discuss briefly about the Dissolution of Muslim Marriages Act of 1939. This enactment consolidates and clarifies the provisions of Muslim law relating to suits for dissolution of marriage by a woman married under Muslim law and to remove doubts as to the effect of the renunciation of Islam by a married Muslim woman on her marriage tie. A woman married under Muslim law shall be entitled to obtain a decree for the dissolution of her marriage on the ground that the whereabouts of her husband have not been known to her for a period of 4 years or more. If her husband has neglected or has failed to provide for her maintenance for a period of 2 years, she can apply for dissolution of her marriage. She can also file an application for maintenance under the provisions of the Protection of Women from Domestic Violence Act 2005 or under the provisions of Code of Criminal Procedure. If her husband has been sentenced to imprisonment for a period of 7 years or upwards in any criminal case, or if he has failed to perform without reasonable cause his marital obligations for a period of 3 years, then also a Muslim woman can apply for dissolution of marriage in a competent court of law. She is entitled to file an application for dissolution of her marriage on the ground that her husband was impotent at the time of the marriage and continued to be so, or that he has been insane for a period of 2 years, or is suffering from leprosy or a virulent venereal disease, since she cannot live with him anymore. A Muslim woman also can file a petition for dissolving her marriage on the ground that she has repudiated her marriage before attaining the age of 18 years if her marriage was performed by her father or other guardian before she attained the age of 15 years, if the marriage has not been consummated. If her husband treats her with cruelty and habitually assaults her or makes her life miserable by cruel conduct, if such conduct does not amount to physical ill treatment, or if he associates with women of evil repute or leads an infamous life, she can file a petition for dissolution of marriage. Also, she can file an application for protection order under the provisions of Protection of Women from Domestic Violence Act and can give a report to the police for initiating action for committing offence under section 498A of the IPC. If her husband attempts to force her to lead an immoral life, or disposes her property, or prevents her exercising her legal rights over it, or obstructs her in the observance of her religious profession or practice, or if he has more wives than one, he does not treat her equitably in accordance with the injunctions of the Quran. She is entitled for dissolution of her marriage. Besides, she can file an application for protection order under the provisions of the Protection of Women from Domestic Violence Act. She can also file an application for divorce on any other ground which is recognized as valid for the dissolution of marriages under Muslim law. However, no decree shall be passed on ground that her husband has been sentenced to imprisonment for a period of 7 years or upwards in any criminal case until the sentence has become final. If a decree passed on ground that the whereabouts of husband have not been known for a period of 4 years, the same shall not take effect for a period of 6 months from the date of the decree. If the husband appears either in person or through an authorized agent within that period and satisfied the court that he is prepared to perform his conjugal duties, the court shall set aside the decree. Before passing a decree on ground that the husband was impotent and not fit for consummation, the court shall, on application by the husband, make an order requiring the husband to satisfy the court within a period of 1 year from the date of such order that he has ceased to be impotent, and if the husband so satisfies the court within such period, no decree shall be passed on the said ground. Notice has to be served on heirs of the husband when the husband's whereabouts are not known. In a suit in which the plea of not knowing the whereabouts of the husband, the names and addresses of the persons who would have been the heirs of the husband under Muslim law if he had died on the date of filing of the plaint shall be stated in the plaint. Notice of the suit shall be served on such persons, and such persons shall have the right to be heard in the suit, provided that paternal uncle and brother of the husband, if any, shall be cited as parties even if they are not heirs. The renunciation of Islam by a married Muslim woman or her conversion to a faith other than Islam shall not be itself operate to dissolve her marriage, provided that after such renunciation or conversion, the woman shall be entitled to obtain a decree for the dissolution of her marriage on any of the grounds discussed already. The provisions of this section shall not apply to a woman converted to Islam from some other faith who re-embraces her former faith. Any right which a married woman may have under Muslim law to her dower or any part thereof on the dissolution of her marriage is not affected, and she shall be entitled to the same. Another important enactment that is made to protect the rights of married Muslim women and to prohibit divorce by pronouncing talaq by their husbands in a unilateral and high-handed manner is the Muslim Women Protection of Rights on Marriage Act 2019. Talaq means talaq-e-bidat or any other similar form of talaq having the effect of instantaneous and irrevocable divorce pronounced by a Muslim husband. Any pronouncement of talaq by a Muslim husband upon his wife by words either spoken or written or in electronic form or in any other manner whatsoever shall be void and illegal. Any Muslim husband who pronounces talaq upon his wife shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Without prejudice to the generality of the provisions contained in any other law for the time being in force, a married Muslim woman upon whom talaq is pronounced shall be entitled to receive from her husband such amount of subsistence allowance for her and her dependent children as may be determined by the magistrate. A married Muslim woman shall be entitled to custody of her minor children in the event of pronouncement of talaq by her husband in such manner as may be determined by the concerned magistrate. An offence punishable under this Act shall be cognizable if information relating to the commission of the offence is given to an officer in charge of a police station by a married Muslim woman upon whom talaq is pronounced or any person related to her by blood or marriage. However, under the provisions of this Act, an offence punishable under this Act shall be compoundable at the instance of the married Muslim woman upon whom talaq is pronounced with the permission of the magistrate on such terms and conditions as the magistrate may determine, and the victim shall be entitled to seek the indulgence of the court for granting maintenance and other reliefs, including compensation and other reliefs under the provisions of the Protection of Women from Domestic Violence Act. No person accused of an offence punishable under this Act shall be released on bail unless the magistrate, on an application filed by the accused and after hearing the married Muslim woman upon whom talaq is pronounced, is satisfied that there are reasonable grounds for granting bail to such person.